The next case on the docket is Estate of FLAIRE MAE ALBEE versus Penny A. Coffey et al.
You have no opponent?
Your Honor, I understand that you were going to give directions regarding the fact that this is both an appeal and a cross appeal.
Yes, but I see there's nobody for the opposition here. Okay. All right, that's okay. Yes, there's a cross appeal, so I'd like to have the appellant address both your direct appeal and the cross appeal in your initial argument. I'll give you however you want to divide that up, and then we'll have the appellee respond in kind. Okay?
Thank you, Your Honor. I'd like to reserve 5 minutes if I could.
Okay.
May it please the Court, my name is Michael Farrar, and I represent Mary Benzenhafer, who is the personal representative of the estate of FLAIRE MAE ALBEE. This appeal involves the appeal, not the cross appeal, involves a very simple question, and that is the proper interpretation of a provision of the Florida Probate Code, in this case 732.301, which is the pretermitted spouse statute. Section 732.301 states that the pretermitted spousal share is, quote, a share in the estate of the testator equal in value to that which the surviving spouse would have received if the testator had died intestate. The appeal judgment for consideration by this court concludes that that phrase does not mean the same thing as intestate share, and the appellant disagrees. I don't know if the court has any questions regarding the why it is that the equal in value phrase and intestate share should be considered synonymous, but I would like to just review the key factors on why, in fact, the intestate share should be considered the same thing as the equal in value phrase.
What do you think the intent of that statute is?
I think that the intent of the statute is to codify what was already existing in the common law and described in Via versus Putnam and in Gainer's Estate versus Gainer's Estate, which is the common law presumed that a man would provide for his wife in his will, and when he did not do so, the law made that presumption for him.
But, you know, I think that's part of it. I think you're correct on that. But in this situation, you know, the ultimate result, if the spouse died one day later, would be that her children would get an equal share to his children, which is probably contrary to both his intent as stated in his will and contrary to what would be the perceived intent from most people, that they would prefer that their children, get priority over say adult stepchildren. Is that a factor as far as why the language might be different in the pretermitted spouse versus the intestate laws?
I would submit, Your Honor, that in this case, it is following the intent of the will, actually not perfectly, because the intent of the will of Dr. Albee's will was to benefit his wife in totality. She was to receive everything, and only if she predeceased him were the other heirs to inherit. Now,
those were also her heirs, right?
I don't believe so, Your Honor. I believe that they were children from yet another prior marriage.
Okay.
So he intended to benefit his spouse, Maxine. He later divorced Maxine and married FLAIRE MAE. So I would argue that if we were to follow the intent of the will would actually require that everything be turned over to the estate of FLAIRE MAE ALBEE. However, as codified in 732.301, the statute determines that only half would go to FLAIRE MAE ALBEE, to the pretermitted spouse. And I literally bolded this in the initial brief, and I just want to highlight it again here, that In order for the phrase equal in value to the intestate share to truly be equal in value, it can only be a fully vested share. It cannot be the equivalent of a life estate. And I quote the Florida Supreme Court case Hodel versus Irving, which states, "There is no question, however, that the right to pass on valuable property to one's heirs is itself a valuable right." If the phrase equal in value is to be given its plain and ordinary meaning, then it has to equal a fully vested 1/2 interest in the estate of Dr. Fred Albee. There's no way around that simple, straightforward understanding of what the term equal in value means. And I would also submit that Gainier's Estate versus Gainier's Estate, the Florida Supreme Court case from 1982, backs up the assertion both on the fact that the equal in value phrase and intestate share are used interchangeably, because the case does use them interchangeably. It also explains why that phrase is used as opposed to just simply saying intestate share. And what Gainier's Estate says towards the end of the opinion is that the testator did not in fact die intestate. The will in fact exists and would be admitted to probate. It is only partially invalidated in order to pay the pretermitted spousal share. And if the court would allow me, I'd like to read from Gainier's Estate versus Gainier's Estate. "The will is revoked only as to the surviving spouse who takes an intestate share, while the remaining provisions of the will continue to be valid." An intestate share is a fully vested share that exists at the moment that the predeceasing spouse dies. Under 732-101, it is the act of death that vests that right in the intestate heirs. Therefore, under the provisions of 732-101, 732-102 regarding the spousal share generally, and 732-301, the pretermitted spousal share, FLAIRE Mae Albee, upon the death of her husband, Dr. Fred Albee, had an immediate right to 1/2 of his estate.
Let me ask you this, and this goes to the cross appeal. Is there any reason that the arguments that you're making to us right now on interpretation of the pretermitted statute could not have been made to the Division of Financial Services?
Yes, Your Honor.
They said, you know, you had 21 days to ask for a hearing, and y'all didn't ask for a hearing. Would there be anything in the statute or case law that you're aware of that would preclude you from making the arguments to them that you're making here today?
Yes, Your Honor. Let's start with the Florida State Constitution. Under Article 5, Section 20, C3, the circuit courts have exclusive original jurisdiction to determine both the settlements of estates and the matters relating to probate. The executive branch, in this case either the Department of Financial Services or eventually an administrative law judge at the Division of Administrative Hearings, are not competent entities to make that determination as per the Florida State Constitution. And that is further described in both 26012, which describes circuit courts as the exclusive courts to hear matters related to probate, and in the Florida Unclaimed Property Act statute 717. Under 717-1242, a so-called restatement states that it is the circuit courts who have the exclusive jurisdiction to determine matters related to probate. The fact that this money was being held in custody by the CFO is not relevant to the rights of the parties to be able to properly say who had a right to this money.
You can have assets that don't go into an estate, correct?
That's true. However,
so if the legislature says that these assets in effect are going into the estate, they're to be determined as the chief financial officer determines, why wouldn't that be an appropriate decision by the legislature and not contrary to the statute? You know, like if you have a life insurance policy, you can leave it to a beneficiary. It doesn't go into your estate. If you have a payable on death bank account, doesn't go into the estate. If you have money that comes into the, that no one's claimed for years and ends up in with the financial officer of the state, why can't the legislature say that's to be determined in a different way than going through the estate?
Those are circumstances that may be applicable to the Department of Financial Services or an administrative law judge making that determination. I would say that under the Florida Probate Code 733-105 in particular, a person who is in doubt as to rights to property or as to his or her share in that property has a right to petition the court, which is the probate court, i.e. the circuit court, in order to make that determination. And if, for example, in the case that you provided, there is an insurance policy in which ordinarily it would pass outside of probate, I would argue that under 733-105 and also under the Florida State Constitution, because it relates to settlement of probate, if a person could attack that proposed insurance benefit by arguing, for example, that it failed because it had the wrong person or the person no longer fit the class of people who were to be benefited, that in fact would be under the exclusive original jurisdiction of the circuit courts.
All right, but if you had requested the hearing, made the arguments you're making today, would you have a right of appeal to a court?
That's true, Your Honor. However, there is no competent court under the APA or under Chapter 717 in order to hear this case. The administrative law judge does not have the right to make a determination as to who is the pretermitted spouse of Dr. Fred ALBEE. As a matter of fact, one of the cases that I cite in my initial brief is the Stedman case, in which a widow made pension claims to the administrative law judge, and the administrative law judge refused to act on those claims until she had gone to the circuit court and established her rights as the widow to receive those pension benefits. And I would argue that interplay of jurisdiction between the executive and the judicial is essentially the same thing that we have here today. Again, simply because the money is being held by an executive agency, that does not in and of itself give it the right to jurisdiction that it otherwise would not have.
In that case you just mentioned, relief was sought first with the administrative body and then went to the court.
That's true, but the administrative law judge actually dismissed the case because she had not obtained the court order from the probate court.
Right. So she had exhausted her administrative remedies.
Well, she did make an initial appeal to the executive branch, and as a matter of fact, Mary Benzenhafer also filed a claim. The intent was actually to not have the money be dispersed, but interpled. That attempt failed. But there is no remedy that either the Department of Financial Services or an administrative law judge could provide to make that determination as to the proper beneficiaries of the estate of Dr.
Well, theoretically, your client could have prevailed in front of the chief financial officer and gotten half, and you wouldn't be here, right?
That is possible, but that would be essentially.
So, do we have an issue with the failure to exhaust administrative remedies?
Well, no, Your Honor, because again, they had no right to make a determination that FLAIRE MAE ALBEE either was the pretermitted spouse or to interpret this statute that we're attempting to interpret here, 732-301. If there are any questions regarding the cross appeal?
No additional questions
No.
at this time.
Thank you.
Right.
May it please the court, my name is Charles Moore. I'm the appellee, one of the appellees in this case. If it's okay with the court, I will start with the subject matter jurisdiction. I think the Chapter 120.68 and the final order, which clearly states that we have made the determination, the Division of Financial Services, Department of Financial Services, has made the determination Dr. ALBEE's family is getting the remaining one half, which is what it came to be known, the 50%, that would be allocated as the pretermitted spouse share, had the pretermitted spouse been entitled to it. They determined we're going to give it to Dr. ALBEE's family, not the pretermitted spouse's family, because she's deceased. Petitioner could have requested an administrative hearing before an administrative law judge to seek to get that decision of the department changed.
Was the constitutionality of that statute as applied to, to this situation raised below? In other words, they're arguing the Constitution provides that exclusive jurisdiction would be with the circuit court on probate matters. Then you have a statute that seems to say when funds come in, they have the first sentence of the statute deals with probate matters, but then the second sentence says if, let's see.
Are you talking about 26.012? Where circuit court has jurisdiction of proceedings relating to settlement of estates of decedents, granting of letters testamentary, and other jurisdiction usually pertaining to courts of probate?
Yeah, well, no, I'm talking 717.1242 subsection 1.
Okay. Yes,
Says
sure.
the circuit courts have jurisdiction on proceedings relating to the settlement of estates of decedents and other jurisdiction usually pertaining to courts of probate. However, then it goes on, the department determines the merits of claims for property paid or delivered to the department under this chapter, which seems to me to include probate matters, or could be probate matters that come in after they've been on claim for years and they end up with the, with the department. What my question is, was there an issue raised as to whether that section, as applied to probate cases, would violate the Constitution, given exclusive jurisdiction of probate matters?
It was not raised before the trial court. Now, in my affirmative defense, I raised that the statute was applicable, but there was no challenge to its constitution. The statute was applicable in that the Department of Financial Services had jurisdiction, but there was no challenge to that based on constitutional grounds. So the judicial remedy was available. Petitioner just chose not to use it. The Bureau of Unclaimed Property issued the notice of intent, said we're giving it all to Dr. ALBEE's family. You have 21 days to request a hearing. The beauty of that and this whole statutory scheme is the money is being held. If you prevail at some point, you don't chase around with a paper judgment trying to collect it. The money's there. The department says we're not releasing it until all the remedies are exhausted. If the petitioner had failed to convince the administrative law judge, the Chapter 120.68 says you take a notice of appeal. You have 30 days to do that. So now you're in the judicial system. So you have your judicial remedy. It's with the Court of Appeals instead of going back through the trial process again, which is what the Administrative Procedure Act was all about in the first place. This is to exercise quasi-judicial powers and take those matters out of the courts. So the cases all cited by the petitioner are all distinguishable. For example, they rely on Canny versus Board of Public Education. And that was a statutory interpretation case where the school board, since they came under the Sunshine Law, all their proceedings were open to the court, or open to the public, but they took the position that their deliberations were not. So that went up on appeal, and the court said no. Florida Supreme Court said no, that is a legislative function, not a judicial function. And if there's exceptions, are exceptions to the Sunshine Law, then it's the legislature, not the judiciary, who will make those exceptions. And they found in this case the legislature didn't intend to do that. So it's pretty straightforward as far as what your judicial remedies are. The authorization for the legislature through Department of Financial Services to exercise these quasi-judicial powers, procedures, I should say. What petitioner's asking you to do is invalidate every final order that's been issued by the Division of Administrative Hearings. And I just, and lastly, on that issue, I just don't think it's good public policy to be told, if you're unhappy with this decision, you have 30 days to appeal, and then just choose to do nothing, and then come back later and argue, well, it wasn't fully litigated. It wasn't fully litigated before DOAH because the petitioner chose not to do it that way. Instead, when they got the notice of hearing, they came back and filed a lawsuit against the same people for the same remaining one-half, under the same theory, pretermitted spouse, 732-301, and the only twist was they brought me in as a party. Are there any other questions on the jurisdictional issue?
I don't think so. No.
Okay. On the pretermitted spouse issue, the statute's clear. There is no statutory interpretation here that's warranted. What the controversy is not between FLAIRE, the pretermitted spouse. Everybody agrees she was the pretermitted spouse. The amount we had in dispute was 50% of the estate. The controversy here is the controversy between the pretermitted spouse's personal representative, her state, and the family of the decedent, Dr. ALBEE. And in every aspect of probate law, not just the pretermitted spouse, the statutes have favored the spouse, the surviving spouse, only. If that person's alive, the court is going to overwrite the will to the extent necessary to provide for that surviving spouse. Going back to the dower cases, courts have consistently held when the surviving spouse is no longer alive, the reason for the spousal share vanishes. The spouse doesn't need it. And the cases go on to say the statute, neither pretermitted spouse or elective share, even the probates, the intestacy statute, provide for the surviving spouse only. When it comes to the surviving spouse's kids, they are not favored like the spouse is. It's for the spouse only.
What are you suggesting is the date which governs as far as if the spouse is alive or not? When the estate's opened, or when the estate's closed, or when?
I'm sorry, I didn't.
You know, you're saying this person doesn't qualify because they died before the money was distributed.
Yes.
Okay. So I'm asking you, when do we cut the person off? If they die when the money's distributed, if we do we close it off, you know, and determine when the spouse is alive, when the estate's closed, when the estate's open? What's the cutoff date?
I would say when it's distributed,
Well,
because otherwise
wouldn't that give incentive for a party to stall, if you would, on the estate? You know, if you had the spouse, the surviving spouse is in bad health, and the estate's open, and there's a request for that share, and you know, you could just keep stall hopefully until the person dies. And
I could see where somebody might at least entertain that thought. Say, well,
for your view, if FLAIRE was alive and she would file the petition, and then before the probate judge signed the order, FLAIRE dies 2 days before that, then Dr. ALBEE's daughter and grandkids could come in and say, Judge, hold off before you sign that order that you were going to distribute it to FLAIRE. Unfortunately, she died, and that's too, you know, now it goes to us, so here's a new order. Pay me.
Yes, and there's a case on that where the just about that happened. The guardian of an incapacitated, albeit alive, although alive, spouse petitioned for the spousal share. But before the judge had a chance to sign the order, the spouse died. So the judge refused to sign the order. Said, you know, there's no spouse. And the court affirmed that. Said, yeah, that's right. Once the spouse dies, there is no further need for a spousal share to take care of the spouse.
Well, in this
Unlike,
case,
go ahead,
in
I'm
this
sorry.
case, we're talking about life insurance proceeds. Arguably, somebody was receiving premium notices or notices of the value of the policy, and when he died, this policy went unclaimed.
Yes,
The argument could be made that was intentionally to cut out who the person that was the surviving spouse, although not included in the will, correct?
if those arguments could have been made, they're waived because they were not made. But yes, I could see that happening.
The process is if the funds are unclaimed, notice is given, and the funds are then transferred to the to DFS, correct?
Correct.
And that's just a turnkey, basically. Once it's not claimed, the company makes notice of the funds being available, right?
Yes, Your Honor. And the state attempts to locate people, or there are companies who do that.
Does our record indicate what happened to Maxine? Did she die or?
They were divorced, so she's treated as if deceased. So the whole statutory scheme favors the surviving spouse. The anti-lapse statute, even the inheritance statute, override the will to the extent necessary to provide for the surviving spouse. But once that spouse is gone, these rights of election of surviving spouse lapse. They vanish. For example, the intestate statute, 732-102, gives the spouse, depending on the circumstances, 50% of the estate or sometimes all of the estate. But when it comes to the spouse's estate, the spouse's devisees or heirs, you go over to 732-103, and there are 7 categories of the decedents rather than the surviving spouse's family. Children, and then parents, and then aunts and uncles, and descendants of deceased aunts and uncles. Then you go back to the grandparents, all of the decedent, and you come down again. Only if you can't find anybody there do you go to the last surviving spouse and start following the same order as to the surviving spouse's kindred. So all of those, the anti-lapse statute provides for substituted gifts because lapses of devises are not favored. So most of us have an anti-lapse statute, most of the states. And Florida's, same thing. It's descendants of the decedent's grandparents and coming down. No surviving spouse doesn't even get a substituted gift under the anti-lapse statute. If the legislature had wanted a substituted gift for the pre-admitted spouse statute, they could have put that in there. They could have put that the surviving spouse will receive an intestate share, and would have some provision that it's per stirpes. They don't do that. Even intestate share wouldn't do it because its intestate share is not per stirpes. They don't even say that. It's rather cumbersome language in 732-103. It's an amount equal in value to the amount which the surviving spouse would have received if the decedent had died intestate. Why such cumbersome language? Why doesn't it say the surviving spouse will receive the intestate share? And the answer, I believe, is they were specifically trying to avoid a windfall to the surviving spouse's kids. Surviving spouse is alive, no problem, plain meaning of the statute, she gets 50%. But once she's gone, there is no surviving spouse to which to make distribution. And of course, our argument is the no statute interpretation is necessary, plain meaning on its face, and it should not be extended to include a class of people that are not listed in the statute. The other part that was raised, well, not on argument, so if you don't want to hear it, just let me know, is that the Uniform Probate Code backs this up. And petitioner cites that the Uniform Probate Code leaves a share to the pre-admitted spouse. But part of that statute is not put in the briefs, or at least it's in mine. It says the surviving spouse gets a share in that portion of the estate that is neither devised to a child of the testator or who is a child of that child. So when you look at the whole statute, FLAIRE's estate would not have taken under the Uniform Probate Code for the same reason. All of the policies favor the spouse only and the legislatures do not want to create a windfall for the surviving spouse's estate or kids or whoever they are. Anything else?
No.
Okay, thank you very much.
Let me ask you off the bat, was the constitutional issue raised below?
No,
The argument that 717.1242 subsection 1 is contrary and inconsistent with the Florida Constitution giving exclusive jurisdiction to probate courts.
No, Your Honor, that issue was not brought up below. And
if it wasn't raised below, I'm struggling, and maybe you can help me out, how you get around the argument that you failed to exhaust your administrative remedies.
Well, Your Honor, the Department of Financial Services was very circumspect in the way that it treated the probate court order and its distribution of the remaining of the one half of the second one half of the money. It stated, and I believe it's in the record on appeal, it is the probate court who determines who the beneficiaries are. We are only the ones who disperse the money. And Mr. Moore and his clients had a probate court order that was issued without my client's knowledge that stated that they received the entire amount of the estate. So the Department of Financial Services, in its notice of intent, stated that it had no choice but to disperse in accordance with that probate court order.
Well, the statute says that any estate or beneficiary must file a claim, but then it says the department determines the merits of the claim. So to me, it's more than just they have to, if the probate order says this, they have to do it. Because why have the language they determine the merits? I mean, why wouldn't they just say, they have to follow the court order on distribution?
Well, assuming that, doing everything we can to make that statute constitutional, the key word is probably claim. As I detail in the initial brief, there are a number of documents that need to be submitted with the Department of Financial Services in order to make an appropriate claim. For example, in a case such as this one, you have to have either letters of administration or an order of summary administration. You have to have a claim form, you have to have identification, and you have to have certified copies of, I believe, 120 days worth of circuit court documents, probate documents. That is the claim. As I describe in the initial brief, what the department does is not determine title. It's actually the circuit courts, in this case the probate court, that determines title. Rather, they make sure that everything is done in accordance with the act, that all those documents are provided and are in proper form. So if the Department of Financial Services were here arguing their position, they would probably say, we have a right to...
If that was the case, wouldn't the legislative scheme be simply the trial court determines that there's, $30,000 being held by the Division of Financial Services and orders the Division of Financial Services to give X amount of dollars to this person and Y amount to that person, and everything's done in the circuit court? Why even have this?
The reason is somewhat speculating. A separate provision of the Florida State Constitution, Article 4, Section 5, I believe, that states that this chief financial officer is the sole person to make a disbursement order of state funds. And so there's a little bit of a tension between those two provisions of the Florida Constitution. There are a number of cases, which I'll be happy to supplement the record or submit them, including Crescenzo versus Atwater. One was cited by opposing counsel called Atwater versus Cape Coral, as well as several cases from the 3rd District Court of Appeal. Atwater versus Citibank FSB is the one that comes to mind, that discuss the rights of the chief financial officer to receive documents and make the ultimate determination on whether to disperse money from the state from the state treasury. So I've always taken 717-1242 to mean that the chief financial officer, irrespective of a proper court order, still has a right to ensure that all the other requirements of Chapter 717 are met. Certified copy of death
Could you
certificate.
have argued, if you'd had a hearing, requested a hearing, argued to the hearing officer that you shouldn't feel obligated to follow these orders because we never got notice of these proceedings and we were entitled to notice?
That would place the administrative law judge in the position of annulling a Article 5 court, which would be the order of summary administration. There's a case on point called International Locators. It's a DOA case, International Locators, in which the administrative law judge states flat out, we cannot override an Article 5 court. Administratively, they do not have the power to override the order of summary administration that Mr. Charles obtained on behalf of his client that distributed the entire amount of the estate to the other heirs, the other testate heirs. If I could, I would just like to emphasize again the fact that we are not talking about an elective share here. The pretermitted spousal statute is a separate statute from the elective share statute. They have different common law origins. The elective share was made so that a widow would not fall into penury upon the death of her husband. Therefore, it is in essence a life estate that is provided. The cases that Mr. Moore cites and talked about here today are all elective share cases. That is not the case with the pretermitted spousal statute. Pretermitted spousal statute is a codification of the common law theory, concept, idea, right, that a man will provide for his wife in his will, and when he fails to do so, the law will step in and attribute that desire to the will. So, Gainier's estate versus Gainier's estate, as well as its predecessor, which came out of this court, in Ray Gainier's estate, demonstrate that there is not a life estate attached to the pretermitted spousal share. In Ray Gainier's estate, the person purporting to be the pretermitted spouse pursued his right for one half of the estate of his deceased spouse, and upon his death, it states in Ray Gainier's estate, that position of pursuing that amount was assumed by the personal representative of his estate.
Counsel, you're out of time.
Thank you.